Good morning.
Good morning, Your Honor. Patrick Rohde and Kirsten Nelson are present for Shanna Gardner. I believe Mr. Baez is present via Zoom.
Good morning.
Good morning, Mr. Baez.
Your Honor, as a preliminary matter, I've had an opportunity to speak to the state regarding juror anonymity and protection. I would make an oral motion, which I believe the state agrees with, pursuant to Rule 2.420C9A1 and 2.450C9B and C to the Florida Rules of Criminal Procedure, that the court take certain action to protect the jurors' information during jury selection and thereafter during trial. I believe the court can enter an order protecting the juror anonymity and their confidentiality and apply means that would be reasonably restrictive to protect the interest of the trial in Ms. Gardner's case.
Okay. And is the state in agreement as well?
Yes, the state joins in the motion and has no objection.
Okay. Thank you for doing that. I know Ms. Gardner's jury selection is going to be after Mr. Fernandez, but I will be able to enter the appropriate orders prior to her trial. So I appreciate that housekeeping on both sides.
Thank you, Your Honor.
All right. And so, Ms. Nelson.
Good morning, Your Honor. Kirsten
Morning.
Nelson on behalf of Shanna Gardner, who is present.
All right, we are here on the subpoena, the motion for a subpoena ducis tecum in Ms. Gardner's case. And I know this has been multiple hearings. And so in review, I kind of started from the beginning, reread the information, and I knew that at least for the public portion of this hearing, if the defense could, again, just identify the sensitive nature that you are requesting that the court take in camera pursuant to Rule 3.220M.
Yes, Your Honor, and thank you for the opportunity. We are requesting that the court consider certain matters in camera because they directly relate to defense theory, more specifically, the defense's intended theme at trial. So what the facts and the evidence we believe will show at trial, and the state does not have a right to discover that pre-trial, nor does Ms. Bridegan, who may be subject to the cross-examination that would help the defense in order to develop those themes before the jury. These are constitutionally protected rights under the Fifth and Sixth Amendments, due process, and the right to confrontation. For those reasons, Your Honor, we respectfully request that the court consider in camera a defense submission regarding theory of defense and corresponding exhibits.
Okay. Is there any objection related to the not argument, but in camera examination related to those sensitive matters related to the Fifth and Sixth and due process?
Your Honor, Steve Siegel on behalf of the State Attorney's Office with Ellen Mizrahi and Christina Stifler, Assistant State Attorneys as well. On the representation that we're talking about a written submission to the court in camera based on 3.220M, the state doesn't have an objection to an in-camera submission of that nature.
Okay. And so what I intend to do, we've got to fast forward this process. Otherwise, it's going to be disruptive to, I believe, Mr. Fernandez's trial. And so the matters that I took under advisement, I'm going to consider the in-camera submission by the defense. I will have an answer on Monday, okay, related to the subpoena. And then I did need to check in with Ms. Bridegan, Mr. Clifton, on the court's resolution of EF. What is...
Mrs. Bridegan has put together those messages. I can provide them by any means that the court would like me to. If it's going directly to the court, the state, Your Honor, how you want me to provide those.
I thought I was, let me look back. I think I was going to do an in-camera inspection, correct? So she's already put those together?
Yes, Your Honor.
Okay. How fast can she deliver those?
We could probably get it done this afternoon, I would hope.
Okay. I'd ask that I will do the in-camera inspection of EF's, that resolution, if you could deliver it to the court this afternoon. I'm hoping that I can work through that.
Okay, it's a series of screenshots. It's okay if I do like an electronic file through the JA? Or do you want it printed?
Is that how it is? Like, you don't have to print it.
Yeah, it's an electronic file right now. Screenshots to her phone, and she'll send me the file, and I can just forward it on.
Okay. Could you do that, please?
Yes, Your Honor.
All right. Electronic is fine.
Thank you, Your Honor.
All right, so as far as the subpoena, I'm going to pass the matter over to Monday. I'm going to consider the in-camera portion of it and then resolve the remainder of the subpoena request. Okay?
Understood. Thank you, Your Honor.
Your Honor, is there going to be a separate hearing on Monday, or is it just an order coming out? I just wasn't sure if I have to be
In
here.
order.
Okay, thank you.
I don't think that you have to be here. And then if there, if there's objection to the order, then, or any other preservation requests, then I can hear those. But I'm hopeful. Mr. Siegel very succinctly said I should deny it. So I hope to get, based on the review, get to a point where I can rule. Okay, thank you.
And Your Honor, defense counsel will not be available on Monday. So to the extent that the court is setting a status, we respectfully request to waive Ms. Gardner's appearance.
Okay, that's fine. And if you want to have a member of your team, or I could just issue Monday and not set it on the calendar, I could do that. Just knowing that I'm gonna get it done by Monday. Okay, and if you all want me to come to court or you want to address anything with me, you can add it on. Would that be more acceptable since you're of your unavailability
That works for the defense.
about the state?
That would be fine, Your Honor.
And then Mr. Clifton, is that okay with you? Okay, so I'll make sure that I service all parties so that if you do need my time, then you can add it on. Okay,
Thank you, Your Honor.
Your Honor, I just had one more matter. We received this morning a additional filing from Ms. Gardner's counsel regarding the issuance of the subpoena duce tecum. It was essentially a reply. I would just like the opportunity to respond to it. I can get you something hopefully later this afternoon.
that's great.
Over the weekend. It won't be long, just a few arguments that I'd like to respond to.
Absolutely.
Thank you.
All right, thank you.
Thank you.
We need to pick a final pretrial date for Ms. Gardner's case. Hopefully not overlapping with the trial. Or if you all want, I mean, you can come, we can do like an 8:30 for Ms. Gardner. If there's some last minute issues that need to be resolved.
Judge, I think that would be fine. An 8:30 at some point.
Okay. Can you all we can always move it, but can we have a target date?
I was going to suggest August 27th, which is a Thursday. Based on my discussions with the Fernandez team, we're hoping to be completed with trial by that date, so we won't be on a time crunch if we set it that
Your
morning.
microphone.
It's on.
Okay.
Judge, that works.
You want to come that close to the jury selection date?
Yes, Your Honor. I don't want to come while we're in the midst of our other trial.
That's fine.
That's fine, Judge, and I think the parties know that if something comes up, we can always ask for a court date.
Mr. Carodi and I were discussing some housekeeping matters this morning. We have some Zoom stipulations we're still finalizing, but if there's an issue that requires the court's attention, we should know that next week, and we can always ask for additional time prior to that.
Okay, so the next court date for Ms. Gardner will be, that's August 27th, it's a Thursday. Do you want 8:30 or you want 9?
I'll defer to defense.
Judge, I would prefer 8:30.
Okay, 8:30 a.m. Final pretrial. And then we'll keep the jury selection dates and trial dates. I do plan to be in communication with the parties, with Gardner, the more that we learn from Fernandez. I'm doubling the number of jurors for Ms. Gardner's case in anticipation that there will be more knowledge about the case. So I also need Ms. Gardner's team to kind of think through some logistical things. For example, in Mr. Fernandez's case, we're bringing up 50 jurors morning, 50 jurors in the afternoon. I've doubled that number for Ms. Gardner's case, 100 in the morning, 100 in the afternoon. But I got to, with the other Mr. Fernandez's lawyers and team, that they wanted, and this is all kind of like food for thought that I want you all to think through for your positions at the final pretrial, meaning that Mr. Fernandez's team wanted to get to 70 questioning jurors. I need you all to get to a number that you believe, both sides, right? That this is the number that we want to be able to substantively question. Ms. Giannacco, how many jurors does this courtroom comfortably seat? How many jurors can we get into the pews? 100. So if you wanted, and you all have not been a part of the discussions, that's why I'm bringing it up now, okay? Our thought process in the Fernandez case has been get to whatever this magic number is, okay? And then we have that number of jurors fill out the questionnaires. You all will have the time to do whatever background information / thought process into your questioning. And from the questionnaires, the parties may glean that this person should not sit, that they are ripe for a cause challenge. I don't think that we should necessarily take up the seat nor the time having that person sit through, you know, a substantive analysis, and we can go through an excusal period based on questionnaires that both sides, maybe you agree. And I did share the updated questionnaire with the Gardner team, didn't I, or no?
I don't believe you did, Your Honor.
Okay, I'll send that out. I would ask Ms. Wilk I'm gonna ask her to send that to you. It'll have Mr. Fernandez's, but I haven't made the changes on it.
Sure.
And so I want you all also to look at the questionnaire from Mr. Fernandez, and if there's anything else that you want on there, if you would let me know. At this point in time, actually, I can give you a copy before you go. Ms. Russell, Ms. Hathaway, do y'all have a copy of it? You don't? Okay. Give me one moment. Does it, Mr. Dreiser, do you have a copy? Or Mr. Hill? Or the state?
The questionnaire, no, electronically, Your Honor, not
Do, okay.
a hard copy.
Judge, was it filed on core?
You've got to scan. Well, I will get you a copy of it. I apologize. I'll make the small edits that need, but I need you all to look at that and see if there's anything that you want in addition to or subtracted from the proposal. What I did do, what was a kind of a more major update is that if and when a juror would identify that they live in the beaches, then they have more questions to answer. I added the social media handles for the potential jurors. Additionally, so that is a thought process, like if the parties agree, we would then excuse. The next thing is that right now we have a report back time. I need you all to start thinking about, and we'll learn from the Fernandez case, a report back window for the jurors to come back. And I think that was all that I need you all. But the magic number is really, so if we can seat 100 in here, okay? We could also fill the second jury box or jury boxes with jurors that listen, fill out a questionnaire, but listen, not question. And so if we do get close, because that is in the Gardner case, we're running up against a holiday. And so then to kind of start the process all over, if we run out of jurors through substantive questions would be, in my mind, kind of a nightmare. So I think you all kind of need to be thinking about those things. So I'm putting all of that out there. And so for the final pretrial, logistics is important to the court so that we don't run out of jurors. And so right now, Fernandez is going to call back 100, the question 70. That's going to be kind of the magic number for them, questioning 70. And so Gardner needs to come up with whatever your positions may be. Okay?
Yes, Your Honor.
All right. Thank you. And, last thing, I'm sorry. I forgot. If through the Fernandez process, we early on figure out that we may need more, I have 500 jurors coming. If you all want more than 500 coming back, you need to let me know sooner rather than later so the clerk's office can send additional summons.
So for Gardner, you have 500 summons going out.
No,
Or you
I have 500.
700 to get 500.
I don't know what they have some formula down there. I don't mess with that. I'm just saying we're going to bring up 500 people. If you believe that you would want more, then I need to let the clerk's office know sooner rather than later.
Yes, Your Honor.
Okay? All right. All right. Thank you. That's truly it. Okay.
Thank you.
All right. Thanks. Thank you.
Hey, Robin.
Okay. Thank you. All right. Are we?
So should I can send an SAL email saying false alarm? Okay, thanks. All right.
Ms.
I
Nelson?
saw her this
Ms.
morning.
Nelson? Melissa Nelson, State Attorney. I think you're off mute.
I'm sorry.
It's okay. All right. Oh, I keep saying this is the last thing. On Ms. Gardner's case, and also for the state, Mr. Smith, who's running the IT for the court, is going to make Zoom available. So if you want, and it will be in webinar form, so if you all want access to that, you need to let Mr. Smith know, okay?
Understood. Thank you, Your Honor.
Outside of the live stream, so if you want webinar access to the Zoom, that's what's going to be running during the course of the trial, okay?
Thank you, Your Honor.
It's only going to be for kind of like in-court party. All right,
Thank you, Judge.
thanks. Okay. Well, okay. Well, they send way more, Mr. Hathaway. They send way more than they need, but so we could say we want.
Stage is ready.
Yes, Your Honor. The defense, on behalf of Mr. Fernandez, Jesse Dreiser, and I represent Mr. Fernandez, along with Mr. Hill is present, Ms. Day is present, and my client, Mr. Fernandez, is sitting right behind me.
And I think I saw Mr. Tassoni on Zoom.
Okay.
Good morning, Your Honor.
Good morning.
Good morning, Mr. Tassoni.
All right.
Little housekeeping. The defense would make an oral motion to have the court order juror anonymity and protection.
And does the state join in that motion as well?
State joins, Your Honor.
Okay. So in the upcoming jury selection, the court, obviously, by previous order, has determined that 2 phases is necessary. The court will enter an order on juror anonymity and also protection in pursuant to Rule 2.420. Taking that rule completely to heart, the prospective jurors that are excused will only be, the court records will only be confidential for the time period that is necessary in order to select the jury. And then once that jury is seated, their information will become available to the public records laws. Then the seated jury and the alternate jurors will also be protected, obviously, for the end of the trial proceedings. And so I'm entering that order today, so I'd ask the clerk's office to file that. I believe that we've talked about, at least at sidebar, some administrative matters, and so I'm ready to go on to substance if you all are.
State's ready.
Defense is ready.
There are a couple of motions that have been unresolved and that, you know, I've been helped because the docket is deep. So I'm going to bring up some blasts from the past. There was a defendant's second motion for bill of particulars, and I think that.
Yeah, that's going to be a star feature of today's issue.
And then there was, on March 30th, 2026, docket line 570, there was the defendant's motion to suppress the cell phone records.
That one the defense withdraws.
Okay. Thank you. I know that we have mentioned it on prior dates, but there was no resolution by the court on docket line 597, filed on April 17, 2026, the defendant's motion to adopt Gardner's motion to exclude minor child.
I believe that was resolved by way of a stipulation of BB.
Okay. Thank you. Could you all find that for me? Do you know what docket line the stipulation's on?
Yes, Your Honor, one moment.
Abandon that one.
Judge Weaver, I believe it's moot because of the state's notice of which counts we're proceeding on. I did provide Mr. Dreiser with a written stipulation regarding BB and the admission of a video. I'm just waiting for them to sign it, and then we will file it.
And it wasn't not signed
Right.
for any other reason than I thought I signed it already.
Oh, okay.
So.
Well, I'll just put, it's fine. I'll just put by stipulation of the parties moot.
Yes.
Okay. All right, and now I think that based on that, going back to the docket line 516, I think that we're now up to date on what's pending. So which one do you all want to take up first?
I think Mr. Mizrahi and I agree we'll take up the defendant's first motion in limine to prevent the introduction of hearsay and impermissible testimony, if that's okay with the court.
Yes. Okay, I'm ready.
So, Your Honor, just let me sort of outline what this motion is as well as the other motion, because they're very much blended, okay? So there's two anticipated statements that we believe the state is going to try to get in. For the purposes, before I get to my argument on the very first motion, they're both statements that we believe are covered by the marital privilege. The state's theory of why they should come in is the marital privilege doesn't apply, at least to the state's first motion in limine. I'm not sure their theory on the second, but it comes in on the state's first motion in limine under a co-conspirator statement. So the reason I bring this up is, number one, many of the marital privilege arguments will go to motion in limine number one, as well as motion in limine number two. In addition, it's our argument, and I do think the state actually agrees with this, that if you find that the statement between, in defense motion in limine number one is marital, we don't have to go to whether it's a co-conspirator statement. It wouldn't come in because it would be marital. So I bring that, there could be some efficiency here to sort of decide whether we need to go into the second argument. If you find it's marital, there's no conspiracy argument to be made, and it would save quite a bit of argument as to those bill of particulars, as well as the complexity of conspiracy law. So I'll let you decide where you're at as terms of marital privilege. But marital privilege in the state of Florida under 9504, it reads, a spouse has a privilege during and after the marital relationship to refuse to disclose and to prevent another from disclosing communications which were intended to be made in confidence between the spouses while they were husband and wife. The privilege may be claimed by either spouse or by the guardian or conservator of a spouse. The authority of a spouse or a guardian or conservator of a spouse to claim the privilege is presumed in the absence or contrary of evidence. Then the statute goes on to very clearly say that there is no privilege under this section under A, B, and C. But I'm going to focus your attention on B because that's what the state is attempting to break the marital privilege. And it says, in a criminal proceeding in which one spouse is charged with a crime committed at any time against the person or property of the other spouse, or, and what the state's relying on, the person or property of either child of either. And that's what the court has to specifically note in this argument. If there's any argument that it was anticipated that by these statements that the state's trying to elicit, that they even would go to the fact that child abuse was anticipated in this case, it would be against BB, who is a child of Jared Bridegan and Kirsten Bridegan. BB is not a child of Mario Fernandez. BB is not a child of Shanna Gardner. The statute is explicitly clear as to that point. I will read to you directly from Earnhardt as the abrogation of child abuse statute, as well as the concept of the statutory construction that it has to be a child of either, is addressed. In addition, there is no marital privilege if the crime charged is against the child of either spouse. Policy reasons require that the privilege not be recognized. The policy is reflected in section 39204, which I will represent to you as the abrogation of child abuse. of Florida statutes which denies the marital privilege in litigation arising out of child abuse cases if the crime has been committed by one spouse against the other spouse or the other spouse or a child of one of the spouses. There is no benefit to the marital relations by suppressing the testimony. There is a public policy to not allowing, in Florida, as you know, one spouse can raise the privilege against the other spouse. There's a public policy reason that you can't prevent your own husband or wife from not talking about the abuse of the children of the marriage. There's no public policy that would allow, and there is not a single case that I can find in the state of Florida that addresses the marital privilege being broken because it's a child of another. And if we look to the Williams case, do you have a copy of that, Your Honor?
Give me one moment. I do. Okay. I'm ready.
On page 2, we find that Ms. Williams' statement regarding Appellate's street name was not protected by the husband-wife privilege because that information was known generally in the community. However, considering the record before us, we must conclude that the trial court erroneously permitted Ms. Williams to testify about Appellate's statement that he needed money to pay his attorney. A communication between a husband and wife is presumed confidential unless there is evidence to the contrary. At trial, neither appellant nor his wife testified whether they meant their communication to be private or public. Likewise, there was no testimony that the statement was made in the presence of a third party or that the appellant instructed his wife to disclose this information to another person. Without this information, it is impossible to determine whether that privilege had been waived. As such, the state did not overcome the presumption that the statement is covered by the husband-wife privilege. Therefore, it was error for the trial court to admit Ms. Williams' statements over defense counsel's objections. And the reason that's so important is, I suppose the state could make an argument that the statement that they're trying to elicit, which has never been clearly outlined, but we assumed that Shanna Gardner tells her friend, Kim Jensen, about a conversation that Mario had with his wife, Shanna Gardner. So it's what Mario Fernandez supposedly said to his wife, not in the presence of a third party, no evidence that was instructed to be shared, in confidence with his wife, and then his wife tells the friend. And in Florida, of course, one party can elicit the privilege, and unless the state has evidence, independent evidence to prove that Mr. Fernandez did not intend for that statement to be confidential, it's a marital statement. Of course, the state also cites the Hill case. And do you have a copy of that, Your Honor?
I do.
Okay. So the brief facts of the Hill case are that a husband and wife have a conversation at some point about whether or not there was any issues regarding the functionality of the cruise control on the car. And in this particular case, the wife, in an extreme tragic, left an appointment. She had her child in the car, and she had a neighbor's child in the car. And her child was killed. And in the Hill case, they go on to say that the abrogation of child abuse statute did apply. And of course, in that particular case, the child of the husband and wife was killed. And what I would point out specifically is that on page 4, when they go through the privilege, they specifically say in B, in a criminal proceeding in which one spouse is charged with a crime committed against the other person or property of the other spouse, or the person or property of a child of either, emphasis added. So this case, clearly the court had the right because they believe that a child of theirs passed. And then the court goes on to a whole nother analysis of the psycho-patient privilege. The state, in this case, has provided State v. Jett, which is the psycho-patient privilege, and it's just inapplicable. Every privilege in the state of Florida has its own statutory construction. There are exceptions for the attorney-client privilege, there are exceptions for the psycho-patient privilege, and there are exceptions for the marital privilege. And there are dozens, if not hundreds, of cases that talk about how the marital privilege is one of, if not the most, protected privileges of all for many public policy reasons. In fact, they all say that if the court were to deny a marital privilege, you can take a writ of cert prior to trial, because in fact, you cannot stuff the cat back into the bag. That's what the case law says. It is so imperative that the communications between a husband and wife are never breached unless there is clear authority from the court that it be breached, that you can take a pretrial writ of cert. I did find, and I sent this morning, the Schwartz v. State of Florida case. Do you have that, Your Honor?
I do.
I went and I spent more time than I'd care to admit on my case law research trying to find one case where the abrogation of child abuse was used and it was not a child of either. I didn't think I'd find one because it's clear in the statutory construction that it says a child of either. But I went as far as I could to find one. And I found a 2025 case, Schwartz v. Florida, 413 Southern 3rd. And in this particular case, it was a husband and wife who presumably had some communications, and then there was a Ring doorbell or some kind of surveillance. And the court ruled that surveillance or observations between a husband and wife are not privileged. And I don't dispute that. I've known that for years. It's only the communications. And in this case, the child that was abused was not a child of the husband and wife. It was a niece of the husband. But in looking to try to find a case, what I found instructive was if you go to the facts and you go to page 5 of 7, Your Honor, where the court rules in favor of the state and says it's not privileged. It was an observation, it was a Ring doorbell camera, and that matter is not privileged. But if you go to the first paragraph at the top, where I do think is instructive, is the last sentence. The trial court disagreed, ruling the footage could come into evidence, but directing the state to present a, quote, truncated, end quote, version to exclude any protected marital communications. If the state's premise is true, and that it can be a child or a niece or a child of anybody, any other couple, they would have never wrote that. They would have said it was an abrogation of child support. This niece was clearly accused of child abuse. It was child molestation. And the court ruled that the marital privilege still remained intact and instructed the state to have a truncated version to not invade the marital privilege. So although I don't believe this case is directly on point, it does give us just instruction that when there's a child abuse case and there's a niece, not a child, the marital privilege is still, in fact, intact. I also would, if you look to the actual statement that the state is trying to elicit, Your Honor, let me find that. Something to the effect of, did Shanna ever tell you that she told Mario that she wanted him to act upon that promise? Jensen, Mario told her, if you don't, I can't remember exactly when the conversation was, but he told her, if you don't want this to happen, you'd better tell me now. And she said, do not. I choose you. I don't want this. I choose you. Ms. Rahi, she told you that she told him that? Yes. Ms. Rahi, but you don't know when that was in this whole timeline? Jensen, I think it was in Hawaii the last time they went, but she said, I don't want this. I don't want any part of this. I don't want you to do anything. And I'm going to read from more of that if we get into the conspiracy argument, because she later goes on to say, I really don't know when it was. It could have been in another trip. But for the purposes of that statement that they're trying to get in, what part of that statement, given that there's absolutely no agreement in there, would give anyone rise that that would lead to child abuse? Ms. Jensen never clarifies, and she's testified before this court, and she's spoken in front of the grand jury, and she's spoken at bond hearings. She never clarifies what that is. She doesn't say whether it's to beat him up, whether it's to murder him, whether it's to make sure that he lives a rotten life. There is no ever explanation, and even more so, the conversation she reports is that Shanna Gardner says, no, don't do that. I don't want that to happen. I choose you. So before we even, I'm not conceding that it is the abrogation of child abuse statute even applies to this case, because it's not foreseeable from that particular statement that this was going to lead to child abuse. If the court's not persuaded by that, BB, the child who, and I don't mean to say this disrespectfully, supposedly was abused in this case, the state dropped the child abuse count. The child was very young. We've deposed all the witnesses. I don't agree that BB had any actual child abuse, physically or mentally, from that. But regardless, BB, and more importantly, BB is not a child of Mario Fernandez and Shanna Gardner, and therefore there is no vehicle in which the state can get that statement in. I would think that it would be most efficient for me to move to my second motion in limine,
Okay.
and then argue the same marital privilege, and then see where you're at after the state argues, and then we can go back to whether, if you say, I don't believe it is marital, if that's the conclusion you come to, then we would argue whether it's a co-conspirator statement or not.
Okay.
Okay?
You can move on.
All right. My second motion in limine is in regard to a motion in limine to prevent the introduction of impermissible testimony, which is statements that AB, who is a child of Shanna Gardner and Jared Bridegan, says in a recorded interview when she is interviewed by a police department, I think in North Carolina. They ask her about some new information, and this is what she says, Judge. Ms. Stifler has told me she's going to introduce the actual 4-minute clip on a CD.
She's, Ms. Stifler.
Do you want to put the video in?
I apologize, Your Honor. I thought we were handling the first one. I provided a video clip to Mr. Hathaway upon stipulation, and I think no objection from defense. It's a roughly 3.5-minute video of a police interview conducted of AB by New Hanover Police Department in North Carolina. Timestamp 25 minutes, 25 seconds to 29 minutes.
And
So this is being published on the media. Do you want to?
how I would present my argument is I transcribed it, not through a transcription agency, but Ms. Day transcribed it word for word. I've shown it to Ms. Stifler. I think she agrees that it's accurate. We can still put it in, but I was just going to read exactly what it says.
Okay. Is that acceptable to the state?
Yes.
Okay.
So just to give some context, Abby's in a child protective type room. A detective's in the room. She's on a couch. And Abby says, in response to some question like, is there anything that you would like to tell me? Some generic question. At my house in Florida, it was a 2-story house, and I was on the 2nd floor, and I had a master bedroom, so I covered like the whole house pretty much. And you could hear what they would talk about. And they would just be like, quote, oh, he'd be better off dead, or something like that. The detective asked who was they, and Abby said, Shanna and Mario. When asked when she heard these jokes, Abby said, It was like for a long period of time. So they did it like months. It was kind of off and on when they would talk about it, but they did it like before he died, and then they didn't talk about it that much during like the 2 months after, but after they kind of talked about it. When asked what else Shannon and Mario said, Abby said, they just said like, he's a horrible person. Like, I wouldn't feel bad if he like died. Like, he has a right to die. He doesn't deserve to be in this world. That's what I remember. The detective asked if they ever talked face to face with Abby about stuff like this, and she said no. Your Honor.
Judge, the reason I wanted the court to watch it, I think there's just the context and how she says things matters a little bit. So just to add, at least from my notes.
Well, you can play it. I mean.
I don't have an objection to it being played. I don't have an objection to the court taking it into chambers and listening to it.
That's fine with the state.
I have no objection. My notes, I believe, are accurate, but admit it in chambers. It doesn't change my analysis.
If you want to play it, I'm just pointing out, last time AB was an issue, you asked for non-publish of the video. I'm happy to hear it if you want and see it, but if it's published on the cart, they would have to kill the videos.
It's a CPT interview, so I do believe there are some protections for public records exemptions, which is why I wanted to provide a copy to the court to review.
Do you want me to do it in chambers? I can. Okay.
Yes, ma'am.
Mr. Dreiser said you were going to play it, so I was just pointing it out. Okay.
You want to do that in chambers now or later?
I can go back now. And
It's only 4 minutes.
I think we could do it later. Let's just get through the arguments, and then the court can.
Sure enough.
That's my thought process.
So, Judge, again, reading directly from Earhart's, however, when there is a reasonable expectation of privacy, and if the spouses intended their communications that their communications are privileged, the privilege applies despite the fact that communications are overheard. If an unknown third person listens through a closed door, and when it is not reasonably apparent to either the husband or the wife that the third party is present, the privilege is not destroyed. When you watch the video and when you hear the statements that I made, AB is clearly talking about being in her master bedroom upstairs. She has like what she describes as a very big master bedroom. And Mario, Mr. Fernandez, and Ms. Gardner are downstairs. And then luckily for us, the defendant specifically asks, did they ever speak with you face to face about stuff like that? And she says no. So again, you go back to the case of Williams, where it talks about privileges, it talks about reasonable expectations of privacy, and it instructs the court that the state has to prove by independent evidence that Mario, Mr. Fernandez, and Ms. Gardner would not have intended that conversation to be confidential. And there is no way from the clip that you're going to listen to in chambers that there is proof that it was done in front of her or they knew, and she starts out the whole premise with, I would be upstairs in my room and they would be downstairs. It's not even a door, as example like Earhart uses. It's a whole floor of a house. So again, I do not believe the marital privilege is broken. I do not believe AB should be able to testify to conversations that you have no independent evidence were meant to not be privileged between a husband and a wife. And we would ask for you to exclude all of the statements that AB allegedly heard by eavesdropping between a conversation between a husband and a wife. If I just have one moment, I think I can turn it over as to those two issues to the state.
okay.
Thank you, Woody, for your help.
All right. Thank you.
Are you done?
Did-
Say, give him a minute.
Oh, okay.
I'm sorry. Yes, Your Honor. I'll turn it over to the state.
Thank you. Mr. Mizrahi?
Thank you, Your Honor. May it please the court. Defense counsel is erroneously stating the state's theory on this, and I'm going to take the court step by step about why there is a clear piercing of the husband-wife privilege in this case. The first idea is that Mr. Dreiser indicates that we're only going on the theory of BB being in the vehicle when her father was shot, which the state had charged as child abuse, and that certainly is one theory. But frankly, the stronger theory the state is going on is that the motive behind this killing, and we will present this with witness after witness after witness, that the motive behind this killing was to eliminate Jared Bridegan's custody of his two children, the children of Shanna Gardner. That is why this murder was committed, and obviously this is a hearsay statement between husband and wife, one of which their children was the goal of why the victim was eliminated. The child abuse statute under 827.03, which I know the court is familiar with, defines child abuse as an intentional act that could reasonably be expected to result in physical or mental injury to a child. There is no other interpretation of that statute than the murdering of the father of two minor children would not reasonably be expected to cause mental injury to the child. It is just that simple. And if that is true, the court doesn't need to make any more findings about whether or not the husband-wife privilege is pierced. But additionally, the state provided, and I appreciate Mr. Dreiser providing the court with the case law, but he neglected to mention the Supreme Court case of Florida that the state provided, Your Honor, State v. Jet, 626 Southern 2nd, 691 is a 1993 case that specifically and unequivocally states, we answer the rephrased question, which is whether Chapter 39, proceedings relating to children, abrogates the privileged communications involving child abuse, whether it only applies if it's one of the caregivers. And it says, we answer, I'll read the question, the certified question, and then the answer. Does Florida statutes 90, and it gives the year, waive the psychotherapist client privilege only as to proceedings brought under the Florida child abuse or neglect statutes? Under 39 and 827, we have jurisdiction. We answer the rephrased question in the negative. We find that the waiver of the privilege in this context reaches to any proceeding involving an action or offense that meets the statutory definition of child abuse or neglect, whether or not the child abuse or neglect is a necessary element of that action or offense. Chapter 39.204 does not in any way, shape, or form indicate it has to be a child of one of the others. It doesn't say that. It says, the abrogation of privileged communications relates to, and I'll read it to the exclusion of confidential communications shall not apply to any communication involving the perpetrator or alleged perpetrator in any situation. Doesn't restrict it to the children of the perpetrators. In any situation involving known or suspected child abuse, abandonment, or neglect. So, Chapter 39, in conjunction with the husband-wife privilege under Chapter 90, clearly sets an exception to cases involving suspected child abuse. And that goes as well to the second motion in limine with regard to AB and the potential eavesdropping. The only comment I would make for that is the state would request a proffer of AB with regard to the issue of eavesdropping if the court does not find what the state is arguing, the husband and wife privilege does not apply to any communications between the co-defendants about the murder of Jared Bridegan, since the goal of that murder was to eliminate the child custody of the victim. And we'd like just, if the court didn't find that, we'd want to proffer that. I just mentioned that. So, but
At what point in time?
when we present it, it wouldn't be an opening or anything like that. I would also, just interestingly enough, the court's worried about our ability to prove child abuse. I would point the court to the Hill case that the defense mentioned, which is Hill v. State, and it's 846 Southern 2nd, 1208. It's a 2003 5th DCA case. And the court was a little bit troubled by the concept that, well, this child abuse, or in this particular case, it was a child neglect, seems a little far-fetched. I want to read to Your Honor what the court said. It says, although we have found no case in which the defendant has been convicted of the crime of child neglect because of his or her reckless driving of the vehicle which resulted in injury to a child, if the defendant's reckless driving is shown to be sufficiently gross, there is no reason the charge could not be proven in theory, because of the clear statutory language in both 39.204 and section 827.03, which is the child abuse statute. We agree with the trial court that the psychotherapist patient privilege does not exist in this case as to any communications relevant to the child neglect. And so we have statements about he doesn't deserve to live, I'm going to kill him, all relate to the elimination of the parent of these two children. Elimination of a custodial parent of a minor child can reasonably be expected to result in the mental injury to those children. We don't have to prove the child abuse according to very clear case law. It doesn't have to be charged, nor do we have to prove the child abuse beyond a reasonable doubt, but the statements have to relate to suspected, remember chapter 39 says suspected child abuse or neglect. And so for those reasons, the husband and wife privilege does not apply to statements made by co-conspirators about the murder of Jared Bridegan.
So what is the state's position as to the first motion in limine to Ms. Jensen?
Well,
and Mr. Dreiser's argument that those statements, to that point, like they're vague, they don't say one way or another.
He's referring to one statement. I think I understand what the court's question is. Well, the state is not just introducing that statement. We will be introducing a series of statements that set forth the concept that Shanna Gardner was trying to hire someone, find someone, ask someone to kill her husband because of child custody issues. I anticipate that the witness will testify to that. Although she will qualify it by saying, at least if she's allowed to say what Shanna Gardner was thinking, which is the subject to another motion in limine, I do believe that Jensen can testify as to what she believed and what she thought. She thought these were all just jokes. But the evidence is an offer was made by Shanna Gardner saying, can you find someone to help me? Jensen accepted that offer by seeking out other people to kill Jared Bridegan. And then the conversation was all about the custody of the children. The elimination of Jared Bridegan was not for any other reason other than the fact she couldn't tolerate this man supervising her children. Her children would go to him, they had joint custody, so every week they'd be gone for 6 or 7 days, and they would have 1 day of visitation, and they would go back and forth and back and forth. We are going to be able to establish that and a timeline continuum that was never broken, under which Shanna Gardner told Kim Jensen, I can't stand my ex-husband, I don't want him to have custody of my children anymore. That's the whole basis of the whole child custody issues in the St. Johns County case, is it was all about child custody. Mario came to the picture, and Fernandez was going to solve this child custody issue. And even Jensen will testify to that he said he could solve the child custody issue. And then Shanna Gardner repeatedly told Kim Jensen multiple different situations under which Mario indicated to Shanna Gardner how Mario Fernandez was going to solve the Jared Bridegan problem. That he could almost touch him, he had people that were out looking for him, he knew people that could do things and help her. They're all relatively vague statements, but remember, they don't have to be direct. If the point is to take care of the child custody issue, and he says, I'm going to solve that, and then as Mr. Dreiser indicates in the last statement, which is a week before Jared Bridegan is murdered because it's during the Hawaii trip, that Kim Jensen says, at that time, Mario Fernandez was unequivocal saying, I am finally gonna make this happen. You have to tell me not to. And then Jensen's testimony is that Shanna Gardner says, Mario told me he was gonna kill the victim, take care of it, get rid of him, whatever language you wanna use, and I told him not to. But that is for the weight of the jury to decide whether or not those statements were really made. The statement from Mario to Shanna Gardner should be pierced because he says, I want to kill the victim, and it's for child custody. Does that answer the court's question? We have years of these statements.
Okay, but what's been identified for the court to rule on is it's very short, it's succinct, and so the defense is not bringing objection to what Mr. Mizrahi is outlining?
Yeah, I'm bringing enormous amount of objection. We now have circulated into the statement of bill of particulars, and it is quite frankly unbelievable to me that the state is now relying on the years of Shanna Gardner's and Kim Jensen's messaging to each other. In Mr. Fernandez's case, it'll take me a minute to get prepared to argue how absurd that is.
Well, why don't I take a break and I'm gonna look at AB's video. But
I'm ready now.
I can't rule on something that's, like what I have sitting before me is not even 2 pages.
Well, certainly we can submit the sworn testimony of Kim Jensen, but until,
Right, but what I'm saying is, so what was before me is a statement. Mr. Dreiser has made a succinct argument saying, and that's why I asked the question, is because the state's argument that Hill applies to the statements of Jensen, saying that the statements go to that, the substance of this statement, Mr. Dreiser has argued vague, doesn't go to any sort of child abuse, and then now the state is bringing in other statements that aren't being objected to. I was just trying to clarify.
Maybe I did important. The statement to pierce the husband-wife privilege doesn't have to, in the statement itself, talk about an act of child abuse or neglect. The statement, they said the Schwartz case had to do with cruise control. So the statement itself doesn't have anything necessarily to do with the underlying crime. It's our duty and our responsibility, whatever our burden, to be able to establish that that was the underlying purpose of the statement. So the statement, I'm going to take care of Jared, doesn't say anything about the children. We are going to establish via other evidence, specifically the defendant's own words, that he was going to eliminate the victim specifically to eliminate his child custody rights over the children. This was all about child custody. So we have direct.
And so what you were proffering to the court would not be statements related to the marital privilege. You're saying that those statements are kind of outside of what is being objected to within this motion.
For us to be able to establish that this was not marital privilege, we will present other evidence, like the defendant's own words after the fact to a third party saying, I did this for child custody reasons.
Where is that statement in discovery?
Excuse me.
Okay.
I'm not arguing right now. I'm paraphrasing, obviously I'm paraphrasing, but we do have
Okay.
evidence of that.
Well, I'm gonna take a break, okay? Let me see AB's video and you all talk, okay? Court's in recess.
Doesn't
Mr. Fernandez is back. Did you all have a chance to talk?
Briefly.
Okay. All right, so I did review the video that was submitted. My impression for purposes of the ruling is that the AB's first statement places her where both sides, I think, maybe agree, but then there's a second portion where the detective circles back, and then she makes the list of statements related to horrible person, all of those things. There isn't a lot of clarity that I was able to glean from either one of those segments of statements. She also, in the first set of statements where initially she places herself upstairs, there isn't, I don't think that can make any findings related to that unless it's clarified. And so I think the state's request to proffer, unless it's clarified in a deposition, I don't think that I can make any sort of ruling based on that is Mr. Fernandez and Ms. Gardner's expectation of privacy.
It's the state's burden.
No, I agree. And so they're asking to proffer. What came to my mind is it clarified some other place besides this video?
Well, it wasn't, because at the time that AB gave her deposition, these statements had not been disclosed. They hadn't even been made yet. They were made a year, maybe two later. And additionally, we've always, even if I was deposing AB, this is the first we've ever heard of this theory. So the child abuse count was always BB. They've dismissed it. I think that's irrelevant. But there's never been an allegation that the children that we should be worrying about their physical or mental health was LB or AB. Never until this morning would have we ever asked a single question. We've never been provided a mental health record of LB or AB. We've never been provided a physical medical record of AB or LB. It never would have come up in deposition.
Okay.
And
So how are we going to rectify the problem?
Well, I think regardless of whether this is eavesdropping or not, it's admissible. I think the statement is pierced because they're talking about doesn't deserve to live. And we're going to be able to circle back by other evidence, and the whole concept of their statements about their discussions about Jared Bridegan centered on the custody of the children. That's what this was all about. I think the husband and wife privilege has been pierced regardless of whether this is an eavesdropping or they have an expectation of privacy or not. I think the court can rule about it. I mentioned only the proffer as the backup, which the court, I mean, we have no problem waiting until we put her on the stand to clarify this.
I think that it's too big of an issue to wait. Number one, it's been brought in a motion in limine. Number two, so if the court follows the state's theory / analysis, okay, what is to stop the state from asserting this sort of theory / in any murder case where the victim has a child and then say, well, all privileges fall away because it would assert mental injury or mental child abuse against the deceased victim's child?
And that's a great question, and the answer is equally as great, because this murder was about the kids. If there's not evidence, if one defendant, a gang member, shoots another gang member out there on the streets, and there's no evidence that the shooting had anything to do with the child custody or the custody of that person's child, then husband-wife privilege would apply. Going back to the whole concept of a public policy, Your Honor, there is no public policy for husbands and wives to discuss the murder of one of their children's father. There is no public policy. Now, we got a little, I mean, it exists, the statute exists. Many other jurisdictions have a crime fraud exception to husband-wife privilege. The state of Florida does not, but it does have this abrogation. And this abrogation is, if this act is about children, then it's pierced. The whole concept of this murder is about eliminating his child custody, eliminating the father of these people's children, And that is an act that reasonably could lead to their mental injury. So it's not in every case. There is no slippery slope. How often do we have murders where the purpose and motive of the murder is to eliminate the child custody? How many murders do we have where we even know they have children? It has nothing to do with the children.
Is there any case that would stand for that proposition?
What-
Ever, I mean,
There is
this
no-
is not a new or novel motive, right? So,
It is a unique motive, and it's very, very rare to have husband-wife privileges that have to do with the murder of the children. I think that's incredibly unique. It's a very rare set of circumstances. I think the case that I cited is the clearest example of where the courts are going to fall on this,
you say Hill.
which is Hill, because it has to do with it's a reckless driving that they've alleged a child neglect to it.
But there's actual, like, it's not a motive argument, it's actual in the facts that the child was, in fact, injured. To me, that's an easier question than what you're asking this court to do.
Well, we have a child that has been injured as a result of this case, an act that reasonably could lead to their injury, because again, I think that the 39 pierces husband and wife privilege, regardless of whether it's their children or not. It doesn't matter whose kids it is. So we have two theories the court can rely upon. One is that BB was in that car with bullets flying by her, which is exactly like Hill, that the person's in the car with crashes happening right now, and that act of child neglect is pierced because of that. Now, I would concede that the discussions about the murder, which is what we're trying to introduce, don't relate to BB being in the vehicle. I concede that aspect. But we do have evidence that this was done, although not expressly made, this was done during a known date night, which the court is aware of, in which BB would always be in the car. One of the children would be in the car, and the murder took place when they knew the child was in the car. So we have that. But the express...
Aren't those facts kind of outside of my universe right now? I know it's part of your argument, but it's kind of...
Well, I mean, the courts have talked about how we have a trial before the trial. I mean, I don't know how else to do
No,
that.
what I'm saying is,
These are matters of the record. The court has heard plenty of sworn testimony in this case, and I'm not speaking outside of that.
right, but the court is also not an investigator. Like, I can't comb through, like, all the hearings that we've had. It has to be kind of a part of the succinct hearing that I'm having right now. I can't go digging for the state when the state has the burden in its argument at this point. Like, if you want me to consider it, I think it has to be the universe of this hearing. I'm not an investigator.
Well, then the state would be introducing and asking the court to take judicial notice of all the sworn testimony in this case. We also will be filing all the depositions in the case. And we would ask the court to do that in lieu of live testimony, because we're going to have a trial in 2 weeks. I know that's a large burden on the court, but these are typically, when we're dealing with motion in limines, which is what the defense has filed, the facts are generally agreed upon, and that this is more of a legal issue.
Right.
I don't think the defense is disputing the fact that the state is going to establish that the motive for this killing was the child custody. We have evidence of that. That will be presented in the trial. And so the question then becomes, is the motive, I think the court has to answer one very simple question. That simple question is the motive behind a murder, if that motive is child custody of minor children, does the murder of that person pierce husband-wife privilege? And it's just that simple. And that's the legal issue I think the court needs to find. And if that is true, then of course, if we go to trial, the state's unable to do that, we undertake that in our peril. But we are going to be able to establish the motive behind this killing was child custody, and therefore the defendant's discussions about eliminating the victim was done for the purpose of child custody, which pierces under Chapter 39 and frankly under 507, I think it is. Thank you.
Say thank you.
I said thank you.
Okay.
It doesn't. 39, the abrogation of child abuse, does not pierce the marital privilege. In Jet, it pierces the psycho-patient theory. psychopatient therapist theory. The psychotherapist is never going to have the child of that therapist who is being abused. So they rely on that statute. Mr. Mizrahi wants to ignore that you go back to the marital privilege statute, which specifically says a child of either. So now the BB, which now they've circled to a new theory that now it is BB, although that's the first I've heard of it. And now they're suggesting that it's because LB or AB could reasonably have an issue that they've never disclosed to us before, that's how it breaks the privilege, because that is a child of theirs. And then Mr. Mizrahi just came in and just told you facts that simply are not the case. He told you just a moment ago that the proffered evidence is that Kim Jensen would tell you it was a week ago. Let me tell you what Kim Jensen would tell you. They had different parenting styles. It was obviously, things were not perfect. And so they would have.
Where are you reading from?
I'm reading from.
I can submit the testimony from Kim Jensen in the hearing, as well as Kim Jensen in the unsealed grand jury proceedings, for your honor.
I bit my tongue, and Mr. Mizrahi did remind me during the break that we shouldn't interrupt each other, and yet I've just now been interrupted.
I was responding to the court's questions.
I had it in front of me. I think the court was asking me what I was reading
Right.
from.
Well,
Gentlemen.
if you're reading it, here you go.
You may continue, Mr. Dreiser.
So in relation on page 82 to the very dialogue that we put in our defense motion in limine number 1, they go on to ask her about when all of this happened. Now, in the very statement itself, she says, I don't know. He told her, if you don't want this to happen, I'm sorry, she starts with Mario told her, I can't remember exactly when the conversation was. Then, in their grand jury, they're pushing her. You know when it was. It was in Hawaii. And this is what she says, bottom of page 82. They had different parenting styles. It was obviously, things were not perfect. And so they would evaluate whether or not they were going to stay married. And so I don't recall if it was that particular trip or, another one. I know that it happened, that conversation happened on a Hawaii trip. Which one, I wasn't sure. And the evidence in this case is they went to Hawaii yearly. So the idea that it's the week before, she says in 2 different spots. And in all of her testimony, she doesn't know when that statement was made. So they're putting facts and evidence today in this quasi-proffer that they want you to believe these things are true. That it is apparent that this is over child custody, because if you look to the divorce in St. Johns County, Mr. Mizrahi told you it would be apparent that they were having child custody fighting issues. No, it's not. There is no motions regarding child custody post-dissolution. And I'll explain what the exception. In this case, there is a marital agreement, consent order.
Mute yourself.
Mute, please.
Mr. Mizrahi. Your microphone.
So they come to a consent order, which means that there was no trial and the parties agreed to 50-50 time sharing. Then for a short period of time, Jared Bridegan moved to, I believe, Utah, and there was then a consent order regarding what the time sharing should be. Then when he moved back, there was a consent order that they have equal time sharing. And then there was a motion about what what school the children should go to, a medical device motion, every single one which resulted in a consent order being entered. These folks didn't go to court one time to resolve their initial divorce, which was agreed child custody, and any other subsequently post. There is no motions that the court will be presented with that they were fighting that one person should have more time than the other, that one parent was unfit, one parent's time sharing should be eliminated because of drugs, abuse, nothing. That's what a typical family law, acrimonious post-dissolution is. This parent's a drunk. This parent's a drug addict. This parent can't fundamentally co-parent, is a parent alienation. All the things that you can imagine, they don't exist in this case. So what he just told you is not what the record reflects. We've agreed on what evidence is going to come into this case. And I have in my exhibits the marital consent final judgment, as well as all of the motions and all of the consent orders to show the jury that, in fact, they want the story to be that. The media wanted the story to be that. That's not what the record reflects in this case. And in fact, my recollection is when I asked Detective Johns, the lead detective, if he had ever even read any of the pleadings in the family law case, my recollection is that he said he had not. So now they want you to adopt this idea that they have a new theory of how they can get in, and I'm going to go right into the co-conspirator statement, Judge. You asked me what happened to our defendant's second motion for bill of particulars, okay? We had a hearing on it, as you may recall.
I do not. We've
Well,
had lots of hearings, Mr. Dreiser.
I understand. Well, I will tell you that the motion was filed on December 24th of 2025, and we called it up for hearing on January 22nd of 2026. I went into great detail with the court. I went through my motion, and I went through the information, which was at the time a 4-count information. I pointed out to the court that all of the folks that are charged all had different date ranges.
I do remember that.
I pointed out to the court that Mario Fernandez's was from November to February. I pointed out to the court that I have no idea why it's in November. I pointed out to the court that Ms. Gardner's was totally different. I pointed out to the court that there were unindicted co-conspirators that they've always alleged. I have known about this statement from Kim Jensen to Shanna Gardner about what my client supposedly said for years. I cannot tell you, and I, as an officer of this court, tell you how many times I have addressed this with Ms. Stifler. And I will represent to you that after the day of this hearing, Ms. Stifler called me on the phone, and she said, I'm not, in the court, by the way, in the record, this will be on the record, she said that she was going to respond. She said that she would outline all of the conspiracy date ranges. She said she would, and the record will reflect exactly what she said, and if we have to rush order the transcript, I will. But I will represent to the court that Ms. Stifler called me that day, and she said, I am not trying to hide the ball. She told me on the phone, November, it's not a magic date. It's sometime when Henry Tenon suggested to us that Mario went to him and they started discussing it. And in fact, I learned for the first time that Ms. Stifler told me initially Henry Tenon supposedly said, I'm not interested. And that at some point he changed his mind, and she told me there was no magic date. They just used November, and I said, okay, that makes sense. Then she told me who my co-conspirators were. And she never mentions Kim Jensen. I have asked her over and over again, because if Kim Jensen's not a co-conspirator of Mario Fernandez, then that statement can never come in. Today, there's this whole new argument as to who co-conspirators are, and statements that Shanna Gardner made to Kim Jensen. I tried to address this months ago, and I was met with a phone call that said, your co-conspirators are Henry Tenon and John Biggerstaff. And there is no evidence. First of all, you should know this has never been responded to. They have never filed a formal response. And when I was told last week for the first time that they were going to try to get in this statement from Kim Jensen, I was on speakerphone with Ms. Stifler and Mr. Mizrahi. And I said, you're now trying to get this in? And Mr. Mizrahi said, co-conspirator statement. And I said, oh, after 3 years of telling me that that's not coming in. They've now decided, without filing a single response to my motion in limine, or my motion for statement of bill of particulars, as to who is a co-conspirator of who. They have to tell us, independent of the statement. That's what the law says. Mr. Mizrahi provided the court with a series of cases, all of which I agree with. That is the law. Independent of the statement, they have to tell you who your co-conspirators are and when the conspiracy is. So now, Mr. Fernandez, the best I could guess from a count that has since been dropped, the conspiracy count, his conspiracy goes from November 2022 to February of 2023. So it's essentially a less than 3-month conspiracy. Now they want to come in and tell you that all of the statements that Shanna Gardner ever made to Kim Jensen should come into evidence because they're co-conspirators of one another. Those statements go back years. So what is it? Are they now just telling you and me for the first time, a week before trial, that Mr. Fernandez's conspiracy goes all the way back to 2016 or 15 before he even knew her? Which I agree is legally possible. You can join an ongoing conspiracy, but they haven't done that. The best they've ever told us is that my conspiracy is from November to February. So is it for the first time today that we're learning that he joined an ongoing conspiracy? Or do I think what their theory was all along until they've recently changed it as they prepare for trial, that there were 2 conspiracies? There was a conspiracy between Kim Jensen and Shanna Gardner, and that they, perhaps the object of the conspiracy was to have Mr. Bridegan killed. And then their theory was, well, once we had Henry Tenon, we have an agreement between Mario Fernandez and Henry Tenon that they want Jared Bridegan killed. That is a conspiracy. That is an agreement. It happens between November. It happens up until February. And now the object of that conspiracy. And they were fine, and it was simple, and it was clean. And their theory was certainly that those are who your co-conspirators are. That's the date range of your conspiracy. And those are the statements that we would be able to get in. But not what they're telling you today. Not what they're telling me today. And they've never filed a single thing to the contrary to tell me, when did Mario Fernandez make an agreement with Shanna Gardner to kill Jared Bridegan? It's never been disclosed. When did Mario Fernandez make an agreement with Kim Jensen that they want Jared Bridegan? When? It had to be between November and February, unless today, for the first time, the week before trial, they're going to tell me that my conspiracy goes back years, Judge. Which, if they're baiting me into a motion for a continuance, I guess that is where we're at. Because we're now talking about what could be perceived as thousands of messages between Shanna Gardner and Kim Jensen as to what their whole plan was before Mario Fernandez may have even met them.
Let me stop you. Is that what the state's doing?
Are we done with the husband-wife privilege, or we want to go?
I believe that we've transitioned into the bill of particulars.
We abandoned the count. We're happy to provide a bill. We abandoned the conspiracy count. I don't know what we're talking about.
Because the conspiracy, it's irrelevant. The conspiracy count is irrelevant. The law says...
Wait. I asked Mr. Mizrahi. Go ahead.
Yeah, the answer to the question is the conspiracy doesn't need to be charged.
Well, so he's asking, in the universe of facts that's going to be tried in a week, what is the state relying on? Because apparently y'all are on 2 different pages.
My job is not to sit down with them and tell them how I'm going to prove my case. My job is to make sure that the evidence that I'm going to use has been disclosed. There is not one thing I have mentioned that has not been disclosed. The court is aware of all of it. Just said, his argument, I have known about these statements for years and years and years. Well, that's what we're relying on. The years and years and years of discovery statements where we see that Kim Jensen and Shanna Gardner discussed how they were going to kill Jared Bridegan and then brought in, pursuant to the defense's own acknowledgement, that 2 people can be in a conspiracy, a 3rd person can be brought in later. We agree Mario Fernandez was not part of those original discussions because he wasn't part of the conspiracy. Shanna Gardner didn't even know who he was. But when that discussion about killing Jared Bridegan, when she married the defendant, Mario Fernandez, she brought him into the conspiracy and continued to provide updates to Kim Jensen, her other co-conspirator, about how Mario Fernandez had planned on doing this. So all of those things have been disclosed.
I agree. So what I also hear, and what I'm asking the state, is that Mr. Dreiser says that he's filed two motions for a bill of particulars. Neither one have been responded to, except for informally. He's saying that the state has given him, I guess, an assurance that whatever is in the universe of facts would not be used against him, and therefore we've got to, I do believe, I think both of you are right in separate silos, right? Like, so yes, of course, everything is within the universe of facts, but if the defense asks through motion and the state says that they're going to respond, I think that you do have to respond.
We responded by dropping the count. We're happy to respond to the solicitation count, but I don't think that's what the defense is asking. If they are, we're happy to send an email, do you want us to respond to that? Because we're happy to respond to the solicitation count. We've abandoned the conspiracy count. How are we doing a statement of particulars as to an account that we've abandoned? That doesn't, the conspiracy count has nothing to do with it. What the defense is essentially saying to you is we weren't prepared for this issue.
That is not what we're saying.
And that we were not anticipating this coming in, and the argument is that the statement of particulars should explore this.
Well, you have. I thought you did tell him, and that's why the motion to eliminate's been filed.
Exactly.
Okay.
I'm saying before. This is not-
Okay.
He's talking about the motion to eliminate from 2 years ago. I say motion, I'm sorry. The statement of particulars, that's what he's referring to, that he would have known about this years ago. I don't know what to tell him. We've abandoned the conspiracy count. We're happy to respond to the solicitation count, although I don't think it's going to provide him any more information than is already provided within the indictment. Shanna Gardner, the question the court has is, has husband-wife privilege been abrogated because of Chapter 39? Really doesn't matter if it's 39, because our main theory is that they're talking about their kids. So whether it's 39 or the husband-wife 90.50, husband-wife, it has to do with their own children. Whether the discussion or a motive of murdering someone pierces them. And that's the goal of the murder, is to eliminate his custody of his children, is that talking about suspected child abuse. And then if it is, then the next question, because that's not the only question, the next question is, does this qualify as a co-conspirator statement? And I think that is very clear. Started to go into that. We were able to establish a conspiracy with Shanna Gardner and Kim Jensen, where Shanna says offer. Kim Jensen accepts that by reaching out to a third person and saying, do you know anyone that can help me with Shanna and getting rid of stupid? We've seen all that evidence. So we have that conspiracy between those two. That conspiracy never terminated. We provided the court the Epps case. The conspiracy exists until it's consummated, abandoned, or terminated. 354, Southern 2nd, 441, 1978 case, First District Court of Appeals. This is well-settled law. And then the defendant, Mr. Fernandez, is brought into that conspiracy that was never consummated, abandoned, or terminated, and starts to provide information about how he's going to kill, paraphrasing, get rid of the victim in this case, again, for the purpose of eliminating his custody over their children. And those updates are then provided to Ms. Jensen. The Gardner provides those updates. This is what my husband is saying he's going to do to accomplish what we have already conspired to do. And then the statements, as already indicated, Ms. Jensen says in her grand jury testimony that has been unsealed, as well as her testimony before this court in the hearing, is that Mario Fernandez was talked. Again, that goes to the weight, not the admissibility. He was a bragger, he was joking, I didn't believe him, all that stuff goes to the weight, not the admissibility. He said on repeated occasions to Shanna, who then repeated it to me, that we were going to accomplish this. Hold on. I know the court heard everything, and everyone in the court could hear it, but we're concerned about other things. So, I've provided the court the idea of the what is necessary to get in co-conspirator hearsay, and adding people. I cite Cam v. State, which is 1983, provided to the court, 433 Southern 2nd 38. It's a First District Court of Appeals. Adding more people to the conspiracy doesn't change the conspiracy at all. And then, more importantly, I guess to respond, and I did not provide this case. I can later, but the conspiracy, and I think the defense will acknowledge this, that the conspiracy need not be charged in order for co-conspirator hearsay to be admissible. And I think we all acknowledge that. And that's Brown v. State, 648 Southern 2nd, 268, 1995, 4th DCA case, as well as Richardson v. State, 338 Southern 3rd, 1106, a 1st DCA case. I believe Your Honor may have been the prosecutor on that case, Richardson v. State. So the conspiracy doesn't need to be charged and alleged or have a statement of particulars to respond to it. The evidence, everything that I've talked about has been disclosed, and we are able to establish the conspiracies by independent evidence. And once we're able to establish a conspiracy by independent evidence, it's admissible, as long as it's a statement in furtherance of the conspiracy. Thank you.
Okay, thank you.
What they're telling you is that because they dropped the conspiracy count, they no longer have to respond because I'm not charged with a conspiracy anymore. So therefore, I then don't have to tell you what the conspiracy is, when the conspiracy was formed, who is in the conspiracy. Who in their right mind, we both agree you don't have to charge it with a conspiracy. Who would charge a conspiracy if you could just go on and leave the defense to guess and to call our team unprepared on this issue when you're sitting in front of a motion where I literally write, Mr. Fernandez is not asking the state to provide its theory of the case or how it will prove the agreement existed, but rather what fact, act, or agreement the state alleges was made constituting the beginning of each co-defendant's charged conspiracies. To suggest that I'm just afraid or unprepared going into trial when I brought this to the court's attention, filed it, called it up for a hearing, was given representations, so much representations, you know how much work the defense has done. You know how many depositions we've taken. You know the lengths that we've gone to take depositions. We've never deposed Kim Jensen because we didn't think we had to because of the representations that were given to us that they weren't using her statements because she wasn't a co-conspirator of Mario. And what Mr. Mizrahi in all of his case law says, that in order for a co-conspirator statement to come in, Kim Jensen, the declarant, has to be a co-conspirator of the person giving the statements, has to be in the same conspiracy as the declarant or the person making the statements. So they have to prove independently that Kim Jensen is in the same conspiracy as Mario Fernandez. And now because they're telling you, well, we abandoned the count, the time doesn't matter anymore. So now, this whole time, I'm basing it off of November to February, and I guess now their theory is, well, we dropped it last minute so we can go back 5 years without ever telling us, which we've asked for, what agreement? Mr. Mizrahi just keeps talking about things that Kim Jensen and Shanna said. And then, well, this is when have you heard one thing that Mario said to Ms. Gardner that would link him to this conspiracy? What act or statement did you hear that Mr. Mizrahi said that would link Mario Fernandez to Kim Jensen? I have to know when that was, and I have to know what it is. I don't need to know their theory, but I am entitled to that. So Ms. Gardner and Kim Jensen and all those comments and all the testimony that he says, yeah, we're aware of, sure, but it didn't apply to us. Because it certainly wasn't November to February. And they just want to have you say, well, they gave it all to you. In what context? Years? So the first time we're learning today, they did file an information. Whether they abandoned it or not, they filed it, and they've represented to us. In so much, interestingly, Mr. Mizrahi brings up the statement of the second count, which is the solicitation charge, and he says, I'll be glad to tell you, I'll be glad to tell you. It's in the jury instructions that they provided in the draft. And it says between November of 2021 and February of 2022 is when Mr. Fernandez solicited. Now he's telling you. So in the jury instructions, they gave you a draft of this week and gave me a copy of. They're telling you, no, it could have been years. It could have been years. How? That's what I'm saying. They don't have to tell me their theory. I have been given a lot of this information. They have to tell us to get in co-conspirator statements. You can't abandon the theory that you have to prove a conspiracy existed. And in order to do that, you have to give someone the time period of the conspiracy, and you have to tell people the act or the agreement. And that's what I've been asking for, and I was wholly misrepresented as to what their theory was and who our co-conspirators were.
Okay. Taking these issues in total, from the defense perspective, which one do you think the court should resolve first?
the marital privilege, because if you find that the statements are marital, they were made in confidence, the state hasn't met their burden, Ms. Jensen's statements don't come in. If during the trial, they decide that they're going to start loading all of Shanna Gardner and Kim Jensen's statements or text messages, which they haven't provided to us as an exhibit, so I don't know why they would be doing that, then we have to raise this co-conspirator hearsay issue. But if you find that it's marital, it's moot. If you find that AB's statements, that one I do agree that if you want to wait and you need more evidence from them, I mean, today is the day, but, you know, I'll let you decide on that.
I wasn't sure, so the ask was for me to review the video. I don't think that that really resolves anything related to, at least from the court's perspective. I think her statements, obviously they're short, but they also implicate a number of statements, where they were made, how they were made. I don't think any of those issues are resolved with that video. And then, you know, Mr. Dreiser had his notes about it, but it's in two different segments on the statements, and I didn't know, that's what I was asking, so I didn't know if they were resolved with a deposition, but now I understand why not. But I would definitely need some type of, before I even kind of went down that road, I don't know how I would resolve these issues with AB.
I think the best way to do it is to see if we can develop, I mean, we can try to do it on our own with the parties beforehand, but I mean, you know, we can also do it in trial. I mean, it's not something we have to mention or go and talk about it. And I know the court wants to resolve all these issues. We're also talking about a minor, and then the administrative rules and Florida statutes encourage us to limit the amount of times that minors are discussed, and I'm very cognizant of that. So, I mean,
I also agree, but also what I'm hearing from both sides is that Mr. Dreiser said the deposition that he participated in and took of AB wasn't contemplating these issues. I hear the state saying that you always knew.
that's not true, no.
Or like that you knew
No.
that you were going to introduce this state. You did not know.
Those statements were provided to us after the deposition.
And, Your Honor,
In a year or so.
Right. This is a long time
we
ago.
deposed AB and LB, I think in early 2025, late 2024. The state's 10th supplemental exhibit, September 19th, 2025, listed the interview that I provided to Your Honor. And in section C of the state's discovery exhibit, it lists the specific statements outlined by Mr. Dreiser. So the state put those statements specifically outlined in a discovery exhibit dated September 19th, 2025. I think we had some discussion about a follow-up deposition.
When was the depo of AB? You went fast.
Let me give you the exact date, Your Honor.
It was before those statements were
Yes.
disclosed.
Way before. I want to say like close to a year.
A year.
My recollection.
So the deposition of AB was September 20th, 2024. The state disclosed the
September 19th.
September 19th, 2025, the specific statements as relayed in AB's recorded interview, including statements that, quote, he would be better off dead, statements he has a right to die, doesn't deserve to be in this world, was a horrible person, and the defendants would not feel bad if he died. I spoke to Mr. Carodi this morning about, obviously the state has no access to AB, and I don't believe Mr. Dreiser had access to her. Mr. Carodi, we were discussing in preparation for trial the ability for both sides to pre-trial with her. So perhaps that might resolve some of these issues if both sides are allowed to speak with her and develop some of these issues, short of a recorded deposition, but in an informal Zoom pre-trial setting, which I believe there's been at least a loose openness to making that happen
Mr.
by
Crody,
her guardians.
do you know?
What's the question, whether or not?
If AB can be available to both parties to resolve some of these issues so I can make a ruling.
Your Honor, I'm not in a position to make a representation, an absolute representation to the court. I can obviously pass the information along, stress that that would help resolve an important legal issue.
When would you know?
Hopefully by close of business Monday.
It takes that long?
Involved in this from the beginning. The Gardners have their own lawyers, and you can't just call like a normal like parent. You have to call the Gardner family lawyers, and the family lawyers meet, and the family lawyers talk to the family, and then the family gets back to their lawyers, and their lawyers get back to us and the state. It's not, and the state is acknowledging that is the course, and they're entitled to do it that way, but it's not as one of these normal issues where you just say, go in the hallway and call so-and-so's parents and see if we can talk to them. It just doesn't work like that. And she's on the West Coast, so there's a time difference. There was, I think, summer now, so there may not be, there was school time issues. So when we did her depot, we did it, I think, starting at 5 p.m. or 7, or it was late on the East Coast. So there's just more issues than typically we see.
So, Your Honor, I will.
So right now, what is it, like not, almost 9?
Your Honor, I also believe there may be some travel involved currently. So again, as an officer of the court, I don't want to represent the court.
No, I
Happen. So do I?
just asking questions.
By Monday, by the end of Monday, I can have an answer and communicate that to the parties in the court. I can tell you there were preliminary discussions with, is Ms. Stifler represented with one of the family representatives, and I think there was an understanding that giving access to AB pretrial to all the parties would be in the pursuit of justice and be fair to everyone. So I can pass along as I get information.
All right. Thank you. I'll need to see you. I want the answer, Mr. Crody, and then I need to see you all as soon as you know the answer. So maybe Tuesday.
Yeah, whenever the court is available, the state will make itself available.
And then I'm also hearing that there's no settle agreement related to the motion for a bill of particulars, both the first or the second. So I'd ask the state to respond. Before I thought it was settled, like you all were, so if you would respond to that by that date.
No problem.
So I'm going to take the motions under advisement.
Your
Okay.
Honor, as Ms. Nelson alluded to earlier, the Gardner team is unavailable to appear next week, and if we could appear by Zoom and waive the appearance of.
Absolutely. I just need it. Honestly, all I need is for, to the extent that you, Mr. Crody, to the extent that you have contact with AB, that you communicate that contact to Mr. Dreiser, the Fernandez team in the state, and then you don't have to be here as far as I'm concerned.
Yes, Your Honor, and for the record, the lawyers do not have contact with AB for Ms. Gardner. Like, we do not have access to her, unfettered access to her. So we will be communicating with the representatives of the family.
Does Mr. Dreiser, does the state have to go through you, or could they contact those lawyers?
They could contact those lawyers.
Why don't y'all do that and just take them out of the loop then?
That would be fine. I've been dealing, well, I won't say dealing. I've been coordinating through Mr. Karodi, who is courteous enough, and that's how we did trial subpoenas, both Mr. Dreiser and myself, and the Zoom stipulations we went.
Why don't we cut out the middle team that doesn't have direct access?
I did ask for some contact information. If they can provide that to me, I'll do that. That's fine.
I will say, Your Honor, that we adopted the motion with respect to marital privilege, so we're involved also and will be participating anyway.
Would you all be, meaning participating, you want to make your own arguments as well? And if there's proffered information, I don't really care the form, but I do care about, generally speaking, motions in limine are hard to rule on regardless, because generally speaking, the court needs some type of context. This, I thought, was purely legal, but part of it relates to some factual determinations, like how, a lot of times the facts are just agreed on.
Yes, Your Honor. As far as argument on the motion, and we've adopted the motion with respect to the conversations that occurred in the home. Obviously, we are in a different posture with respect to the communication alleged by Ms. Gardner to Kim Jensen.
Yes, I agree. I'm speaking solely related to AB, solely related to, because, hypothetically, how and when these conversations occurred, it sounds like no one explored. No one knows. All of it is assumption. And so if it was like made in the open air in the kitchen and she wasn't upstairs, was there a marital privilege? That matters,
Yes, Judge.
If it was behind a closed door, as is one of the cases, that matters. And no one's explored it. No one, do y'all even know the answers?
I mean, the detective said, the detective asked if they ever talked face-to-face with Abby about stuff like that. She said no.
Right, but stuff like that, she could interpret that meaning like they talked directly to me, not I was sitting in the kitchen while they were talking while, whoever was making spaghetti dinner.
Well, it was 25 seconds,
Right.
like the same conversation.
Well, as lawyers, you all know that direct questions to direct answers, she also said they talked about it for a long time.
Right.
So that, the way that police question and the way that lawyers question, two different things. Unless y'all can agree that that is like, that this, all the statements were made and she was upstairs in her master bedroom and all of the statements were, they were separated and downstairs and that they weren't intended, then I don't know how to even rule.
Yeah, none of the parties know the specifics to that answer. We can endeavor to do that. The state's position on all this is that it's irrelevant except as a backup. So if the court were to find marital privilege for all these things.
I'm interested, I guess this is the first time I heard the state's theory, because I was always kind of operating that it was BB.
Right,
So-
and I want to point there, because we have taken the deposition. I don't want to spend a lot of time arguing about why we think there's a conspiracy between the defendant and Ms. Gardner. I think the court is aware that there's discussions between the two of them about Jared Bridegan's elimination. We have a specific piece of evidence that is new to the case that we filed our 18th supplemental discovery on. We have taken that witness's deposition. We have not gotten a transcript yet. But in the state's disclosure, I want the court to be, this is directly from the defendant's mouth. So this is substantive evidence of the defendant to this witness that defendant stated that his wife wanted to put a charge on the victim, that he told her they should just kill him. Fernandez stated they didn't want the victim around because of the kids. So that is, I just want the court to be where we do, and the defense is going to have a lot of cross-examination on the credibility of all of that. But we do have independent, direct evidence that the defendant was doing this for the purpose of eliminating the custody of the children. Therefore, state's theory of abrogation of the husband-wife privilege has been met as previously argued, but we do have evidence the court can look at in our disclosures.
Would you agree that those statements were made?
No, I would not agree that those statements were made. I agree that some 12-time convicted felon heard those statements supposedly from my client in 2024 when he was actually cooperating in another homicide case with that office and doesn't disclose it, gets out of custody, comes back into custody in late June of 2026 on a $5 million bond, and then reaches out after telling his mother to Google it, and then calls the state and says, get me a meeting, and then about 10 days ago, we find out that this snitch from 2 years ago has information, none of which is information that you could not have found on the news. So no, there is not a juror in the world that will believe this person, nor do I believe it would even make the threshold. It's not even a weight for the court to determine the weight of evidence to allow theories, especially in context of a co-conspirator statement. There has to be independent evidence by a preponderance of the evidence that there is a conspiracy, and then whether or not those statements can come in, I don't even think it would make muster with the court of how incredible this human being is. So if that's how they've come up with their new theory, it is, it's so factually disgusting that no one would find it to be credible. And I look forward to them putting that person in front of the jury as to their final admission that they got from Mr. Fernandez, because I don't believe there's any other statements between Mr. Fernandez and Ms. Gardner that they intend on admitting, where he says there's lots of conversations between them as to eliminating Jared Bridegan. There's not. I don't know what they're talking about. There isn't in this case.
Okay.
And I be heard? Just briefly.
Yes.
I heard Mr. Dreiser just say the answer to the court's question was yes. There is evidence of that. Whether it's credible or not is a different weight, not the admissibility. There is incredible evidence of a conspiracy in this case beyond the defendant's own admissions that because we're talking, it's hard when you have two different issues. So the regard with the custody issue is not just proven by that person, but is proven by the circumstantial evidence. We do have direct evidence from the defendant about him stating that he was there to help with child custody issues, that he would take care of child custody issues. It's not just this witness. We have multiple witnesses that would testify to that. But we also have overwhelming evidence that there was a conspiracy in this case. We know that multiple people were involved. When the victim was killed, there's a person that fled on foot and a person that fled in a vehicle. We know that Henry Tenen left his DNA behind on that tire, and that we know that Henry Tenen was not driving the pickup truck that fled the scene. And we know that the defendant, Mario Fernandez, has a connection with Tenen based on the relationship of being landlord-tenant, but also their communications between each other. So we know that they have communicated in the days, weeks, and on the day of the particular crime and afterwards, which afterward statements are not conspiratorial in nature. But we have the other co-conspirator, Shanna Gardner, and this defendant, Mario Fernandez, being the LLC co-managers of the account that ends up paying Henry Tenen. So when the court, all of this evidence establishes the conspiracy. It's just the most easiest one to do it is the jailhouse witness. I want to also, I think I pointed this out before, that the reason why Kim Jensen involved in conspiracy is she, independent of the ask to find somebody, actually asked. So she took the affirmative step of her own to try to find a person, which shows that they were involved in a conspiracy. So we have ample evidence that both of these people are involved in the conspiracy, and the conspiracy was with regard to the children. And in other words, eliminating the child custody issue. That's the only motive in this case that is really pertinent and significant. And so for those reasons, we don't think the court even needs to get to the finding with regard to AB. However, of course, it's always better to have more reasons to admit evidence than less reasons. And so if the court wants to figure out if that husband-wife privilege was abrogated based on a lack of expectation of privacy, we will endeavor to do that to see if we can provide the court more information.
Okay. So you do agree, well, you're agreeing the marital privilege obviously has to be resolved prior to, but before I was under the impression that there was some sort of understanding between the parties, so I am going to ask the state to, in short order, respond to the motion for bill of particulars, okay?
That's as to the solicitation, we'd be happy to do that.
We have to know how they're getting in co-conspirator statements. It doesn't matter whether it's charged. Mizrahi brings that to the court's attention because that, in fact, is the law. Whether it's charged or not is not the analysis. It's whether or not they intend on establishing independently with the evidence in this case that Kim Jensen and Mario Fernandez were in the same conspiracy. Every single case Mr. Mizrahi provided you says that that's what they have to do. So it has nothing to do with the solicitation. If they want to get Kim Jensen to make a statement about what Mario Fernandez said on the theory of a co-conspirator statement, they have to prove independently without that statement that Mario Fernandez and Kim Jensen were participants in the same conspiracy. And I think if you're going to make that argument, you got to tell me when the conspiracy was and what the date range was. And certainly, although there's circles being thrown in the air of what Mario and Henry Tennant have going on and what Shanna Gardner and Kim Jensen, I keep referring back to, you have to link the parties. You have to show that Mario Fernandez joined the conspiracy of Shanna Gardner and Kim. And the only thing that Mr. Mizrahi said that even had a scintilla of argument as to suggesting that they were joined was a payment that exists after the conspiracy ended. Because I once will again say they listed it from November to February, the date of the homicide. The payments are in March. So the one thing that he said that possibly could link the two are outside the conspiracy date ranges.
So I'm looking at the second bill of particulars. It is related to the conspiracy, not the solicitation. It's a request citing the law. So to the extent it's in the papers, I'm asking the state, ordering the state to respond to it.
Our order has been filed by saying we dismiss that count. There's no law under the statement of particulars that we give a statement of particulars as to an uncharged count. That's nonsensical. So I can't provide a statement of particulars on a count that we've dismissed. And Mr. Dreiser is although 90% of the arguments on the legal issues he's been 100% right, 90% right on, he's 100% wrong on the fact that we have to prove that Kim Jensen and Mario Fernandez-Saldana were in a conspiracy together. We have, in the case law, is very clear. We have to prove that they are in the same conspiracy. So as the court's aware, in drug cases, you're going to have multiple people along the train of distributing narcotics that may not talk to each other. So we do not have to prove that Jensen and Mario agreed together. We have to prove that Kim Jensen and Mario Fernandez-Saldana were both part of the same conspiracy, in which that conspiracy is the elimination of Jared Bridegan.
He's 100% correct.
Okay, yeah, there you go.
What he's wrong about is they have to prove that Mario Fernandez joined that conspiracy. He's right. They have to be in the same conspiracy.
I just have an issue. So I'm looking at the actual file document. And if the state's response is that we've dropped that count, then that is a response. And if you want to amend it to what you're asking, we're getting far afield of like what's in the papers is, I guess, my point.
Yeah, the statement of particulars, I believe, is a non-issue at this point. I have provided the evidence to the court, and it's already part of the record, about how Kim Jensen and Shanna Gardner were involved in the conspiracy.
Are you filing that? You want to file these?
File what?
What you handed up?
We can. I mean, I think they're already,
they're
already part of the record. I mean, it's the transcript.
What I would like to do is instead of, and it's for ease of myself and probably the environment, okay? Like if y'all have transcripts, you can give me an electronic version. It's easier for me to search and look. So.
I mean, we need to, for the.
So I want what is in the record to be complete. To me, that was part of the reason today. So what's in I'm looking at the defendant's second motion for bill of particulars. It relates back to the first one, which talks about the inconsistent dates of the conspiracy. And so that was the ask. And then, so whatever the state's response is, let it be responsive to the papers. And if the state's response is that we dropped it, okay. If you want to amend, amend. And then we're going to be dealing within the scope of what's before the court. And so I'm ordering the state to respond the way you're going to. And then whatever the response is, but we're way out in left field.
All right, we'll just know that the trial will be filled with constant, which is fine, that's our job, is to constantly object, and we will,
No,
to every single statement that they try to get in until they independently prove that there's a conspiracy. And
Okay.
we'll just guess when that is and hope that,
or we can try to handle it pre-trial with your papers, but right now,
I
what
tried.
is before me?
I'm ready for trial.
Okay,
Let's go do that.
all right, but
Response.
I'm going to request, and I'd like, if you all are going to impeach, I'd like for it to be electronic if it could.
Understood.
All right. I can return these back since you're.
Yeah, we'll do it, because we have more to submit, the bond hearing and things like that, if the court wants to look at the
If
facts.
you all also, the transcripts, if you could OCR them so they're searchable and put them in order. Like, for example, what I'm asking is if, for example, witness Ms. Jensen, if she's got 3 transcripts, okay, put that in a folder for me so I can click on that so I don't have to search between files. So witness has multiple transcripts, put it in a folder for me so that it's organized that way and I can find it quickly
Understood.
to rule.
And there, if we're moving on from this issue, we do have a state's first motion in limine.
Okay. I'm going to take 10 minutes, okay?
If I may, I'm going down to Judge Cooper's courtroom real quick. We started detention at 1:30.
Okay,
And I'll be right back.
sure. All right, court's in recess. right, thank you. Mr. Fernandez is back with us, and we were going to take up the state's first motion in limine docket line 624.
Yes, Your Honor, thank you. May it please the court. The state's first motion in limine has to do with questions of inmates that the state may call in the trial. And I think the law is pretty well settled here that the state of Florida will not object to questions about the pending case of the inmate. And this stems from the defense's motion to strike the witness that we then tabled and redid his deposition, if the court remembers all of that with regard to the invocations and things like this. So I think that the disagreement between the parties comes down to how much into the particular case that the defense can go. And so the state's position, and we cited Jackson v. State, 25 Southern 3rd 518, as a Supreme Court case in 2009, the defense is allowed to say, you are charged with X, you are facing Y. There is a minimum mandatory in your case. You could go to prison for 100 years. You haven't resolved your case yet. It is still pending. We agree that all those are permissible cross-examination statements. The defense has indicated that they want to go further and say, not just what you are charged with, but who is the victim of your case. You are accused of shooting your wife. You are accused of disposing of the evidence of the case, and there is evidence to support you throwing away a gun. That's the line that the state feels like is improper, and the court should deny the defense's ability to cross-examine beyond the nature. The word nature, they cite Henry for the proposition that they can get into the nature of the charge. But actually what Henry says is what I've listed in my motion in limine is what they're allowed to get into. So we agree they can say it's second-degree murder, that he's facing 25 to life, he hasn't resolved his case, he could go to prison for his life. We agree with. What we don't agree with is him saying, and you are accused of shooting your wife and throwing away the firearm, and good facts that go into in detail that are still disputed by the defendant as he's pled not guilty. And the phrasing of this is what the state has accused you of doesn't save their inability to go into those specific facts. So I think their argument is that, well, he won't even vote because we're just saying what the state's accusing him of. But that still goes into the facts of his case and is not relevant for bias.
Right, Mr. Hill?
Yes, ma'am. Your Honor, I want to let the court know exactly what witness we're going to be dealing with and what we experienced when we were in depositions. This is Emmanuel Alexander. He came into his deposition and told us that he had been in no short of 7 to 10 or more car wrecks over the history of his life with traumatic brain injuries, and his memory was worse after every single car accident. He had had multiple drug overdose and suicide attempts in which his memory continued to get worse. He self-diagnosed himself with dementia, and when questioned, could not remember his conversations with the state attorney's office the day prior to our second deposition, when we had placed the motion to strike the witness on hold in order to conclude that deposition. So we have a couple different issues that are a little more than just simply his bias, but also his ability to accurately remember, which goes to what will be one of the standard jury instructions provided to the jury, which is 3.9, weighing of the evidence, which is going to be whether or not he has a memory to accurately reflect on the stuff that he's testifying to. So, but I want to kind of start back at the beginning because Mr. Mizrahi brought up what we are allowed to question, which we're in agreement. I'm allowed to ask him what he is charged with, what his maximum punishment is, whether he's been offered any favor by the state attorney's office. We have no disagreement on that. I do believe that we're allowed to ask him, and the reason I say this is that we're allowed to ask him, you've been charged with attempted second-degree murder or you've been alleged to have shot your wife. The reason I bring that up is because he specifically states in his sworn statement that was provided in discovery, which would be page 4 of 11 of his sworn statement, it's not been filed with the court, that he states The thing that made me sour in the relationship with Mr. Fernandez was when he used profanity towards the victim's wife and widow. I think it's important that the jury would be able to weigh his credibility where he's saying, I'm so offended that Mr. Fernandez used the B word and the C word in describing how he felt about Ms. Bridegan, but at the same time, he's charged with shooting his own wife. And so I do believe that goes into weighing his credibility with regards to the jury's ultimate fact-finding. He's not going to be asked to admit whether he did those things because, as I mentioned, he says he has no memory of anything. He said that in an evaluation where he has amnesia, doesn't remember the events at all. He's also been accused by the defense of tampering with evidence in this case. The discovery provided by the state includes handwritten notes by Mr. Alexander, which we believe he's tampering with evidence in our case, and in the case that he has pending before Your Honor in his own case, he also has a tampering with evidence charge, which is specifically throwing the firearm into the woods, which is captured on Ring camera. Again, he says he doesn't remember anything. He acknowledges that he has seen discovery that purports to show him throwing and tampering with evidence by throwing this very firearm into the woods. We believe that is relevant. Our defense to this witness is he's tampering with evidence. He has no memory of his discussions with the state or with other people, and on one occasion couldn't remember a question I asked him 2 or 3 minutes into his deposition, and that he has denied that he tampers with evidence, that he's pled not guilty, and we're not going to ask him whether or not he is guilty. I can envision asking him, do you recall that the state has charged you with tampering with evidence? And he'll say, yes. I imagine he'll say, I recall they've done that. If he says no, we'll ask him, Mr. Alexander, have you seen a video of, in fact, what the state alleges is you tampering with evidence? We believe that's absolutely relevant because the jury's going to have to determine whether he has an accurate memory, which goes to his credibility. As to the statements regarding his wife, I think it correlates back to what he says was so offensive that led him to come and cooperate against Mr. Fernandez, was that Mr. Fernandez used profanity, but the jury should also know that though we're not going to ask him whether he did it, that he's charged with attempted second-degree murder of shooting his own wife. So the jury should be able to weigh that evidence as far as, okay, he says he came forward because he was so offended, but yet he's also accused of shooting his own wife because that is a big conflict in his position. To be offended by words, but in essence not offended by shooting his wife, of which we're never going to ask him if he did that. He's pled not guilty. We have no reason to ask him something that would invade upon his Fifth Amendment right. I did cite, or I did forward to the court as well as to Mr. Mizrahi, but it's stated and cited within the Henry case, which is the Bell case, which the court did allow questions about what charges an individual had, and that defendant tried to invoke his Fifth Amendment right. At the time, the court sustained that. It was reversed and said that those questions were permissible, but they further went on to cite these were matters of public record. And specifically, matters of public record, we have the information that was filed by against Mr. Alexander by Christina Stifler as to count 1, attempted murder in the second degree, attempt to kill Tasha Alexander, a human being, by shooting said Tasha Alexander, and during the commission, the aforementioned attempted murder in the second degree, Mr. Alexander did actually possess and discharge a firearm. So I'm not asking him any questions that are not a matter of public record and do not invade upon his Fifth Amendment right. The state wants to limit it to simply saying, you're charged with attempted second-degree murder, you're facing a 25-year mandatory minimum. They're bringing this witness in who, by their own admission, he's not a great witness, he's charged with terrible crimes. They've not offered him any type of plea deal, he's not pled, but they also want to sanitize this witness so that when the jury hears how offended this witness was by the alleged statements of Mr. Fernandez, they can't also know that he is charged with attempting to kill his own wife. So it seems disproportionate, and they claim that there's some prejudice that they would suffer as a result. In paragraph 3 of the motion, the prejudicial effect of such evidence or inference outweighs the probative value. I've yet to hear what the prejudice is to simply stating what is in the public record and asking Mr. Alexander to acknowledge that that is what he's been charged with. Whether he acknowledges he did it, we're not going to ask that question. The Henry case specifically, though we did cite it in a previously withdrawn motion, that was about asking about plea deals and inquiring into that. And one thing that's important is that that was reversed because there is wide latitude on cross-examination. That's a Sixth Amendment Confrontation Clause issue, and the courts regularly are reminded that there is latitude for the defense to explore because credibility of what is going to be a key witness in the state's presentation against Mr. Fernandez, he should be able to inquire for the jury's benefit as to the nature and specifics of the charges in which he faces. The Jackson case, that was asking this witness whether he that was for a kidnapping trial and was being cited simply to state that the question that we're asking does not establish bias, but it's not limited to bias, as I mentioned. This goes to specifically the weighing of the evidence and whether this witness has an accurate memory. I anticipate he's going to take the witness stand and says he doesn't remember a lot of things. That was kind of a theme of our deposition. I don't think Mr. Mizrahi will disagree that Mr. Alexander, on many, many, many occasions, probably far too many to count, would say that he doesn't remember and would apologize at how poor his memory was, which ultimately led to him telling us that he believed he had some sort of dementia. So I believe that the Jackson case, though it is a Supreme Court case, is isolated to bias. But again, the reason we're seeking to expand upon just asking what he's charged with and simply allowing us to expand on the nature of the charge and the specifics. He's charged with attempted second-degree murder, alleged to have shot his wife, that she is the victim. As far as what's important for the court to note, I do think the Bell case is also instructive, is that the examination is not limited simply to the facts that were pending against the witness. It states that the inquiry can be made regarding the specific nature of those charges. That case has been emailed to Your Honor. It was also cited in Henry, but that's Bell v. State, 614 Southern 2nd, 562, out of the 3rd District in 1993. I think it would be impermissible to allow Mr. Alexander to hide behind just the words of the charge itself and not allow what's in the public record to be asked of him because he's placed that at issue. Once he said he was offended by the statements of Mr. Fernandez, I do think it's ripe and appropriate for cross-examination to simply state, Mr. Alexander, you've been charged with attempted second-degree murder for allegedly shooting your wife. And that's what's stated in the information, which is public record. The tampering with evidence, again, not to belabor the point, but we did state that we believe the defense of this witness. He will come in and state that he handwrote notes pertaining to this case, his own case, as far as how it included Judge Kite. And we do believe that it does show that he has a history of tampering with evidence. I anticipate he'll do what he did in his deposition when he didn't want to answer a question, is that he'll simply say, I'm sorry, Mr. Hill, I just have a really bad memory. I do a lot of drugs, I've had a lot of head injuries, and asking him whether he's aware, which he did answer in the affirmative, that there's a video that purports to show him tampering with evidence, I think also is appropriate for cross-examination.
Isn't what the defense is arguing almost as if door opening, meaning that it has to kind of occur before you can delve deeper for it to be wide latitude? Correct me if I'm wrong, what I hear, so first issue, he is so offended. I know that might be prior testimony. He may be cross-examined on his reasoning why. Isn't it dependent upon his answer in open court about where you go from there? So it's almost like A and B have to occur before you can go to C, which is kind of beyond and delve in to then impeach or to show additional bias. And so so that's my first question. The second question is what I hear you say, which is the evidence tampering. Isn't it also dependent upon, you're saying, well, he's gonna feign a lack of memory, so therefore I should be able to ask on cross-examination, isn't it true that I don't think anyone is disputing that you can say you have been charged with evidence tampering, and it's pending. But then the second thing is, now you get to introduce facts. I find, this is my question. I don't believe the rules of evidence would allow you to then go into, and then introduce a fact that is outside of when he feigns or if he cannot remember. Cannot remember is a refreshing situation, is not an impeaching situation. And so then he has to be refreshed about what you're even referring to before he can be impeached with or ask questions about, because the rules of evidence do not allow a party to introduce facts that aren't a part of the universe of facts to somehow impeach him. So on question one, isn't this just a door opening situation? And then it has to happen kind of real time.
So to answer question one, I don't necessarily disagree with the court. However, the state filed a motion in limine in anticipation that that's what would happen.
Right.
Okay.
So we're in hypothetical land.
So when the state and I and our various teams were in this deposition for a period of 2 days, a lot of the responses were, I don't remember, and we were back and forth with this individual's memory. And with the statements regarding how offended he was about what Mr. Fernandez said. The state asked if we were going to go into this, and we said yes. Hence why they filed this motion in limine. Okay. So I don't necessarily disagree with you. I think the reason we withdrew our motion to strike this witness is we said this may end up being more of a trial issue at this point. But the state then filed their motion in limine, which led us here today. I don't know what he's going to say in trial, but I anticipate he's going to say something to the effect regarding his memory. That's why the tampering becomes relevant. And with regards to his statements of how offended he was, I do think at that point, if that testimony is consistent, based upon the sworn statement he provided to the state, which I anticipate they'll ask him, why did you come forward, Mr. Alexander? You've not pled to your charges. We've not offered you a plea deal. He's going to say, I was so offended by these statements by Mr. Fernandez. When that was made clear that we then were asking him, aren't you also charged with shooting your own wife? How do you reconcile being offended by bad language but not being offended by the allegation that you shot your wife? We didn't go into asking him specifics of whether he did or didn't because he has a Fifth Amendment right, and we didn't invade that right. So the state did file their motion. That's why we're here. That's why we're seeking guidance. I do believe, and we did discuss that we thought it was more of a trial issue once he said whatever he was going to say. I don't know if
I think we have to wait until he says what he's going to say.
I disagree, Your Honor.
How so? I mean,
It doesn't matter what he says. The only way this stuff comes in is for bias. That's it. You can't talk. He has not been convicted of anything. They are trying, he actually said it in his argument just 2 seconds ago, that they can't go further. Let's assume that the witness's response to all of this is, I'm not guilty of that. That's why I wasn't insulted by it. He has a pending case, a Fifth Amendment right to remain silent, and he cannot be impeached based on our allegations. He can be impeached based on the bias that he has because he's facing these time, and that's why that's admissible. He is facing life imprisonment, therefore they're allowed to cross-examine him. Isn't it true you're just testifying to get a good deal from the state? What they cannot do is say, isn't it true that you're not insulted by women because you shot your wife, or under the guise of you're accused of shooting your wife? He has no ability to respond to that. It's a pending case. It's not proper impeachment under any set of circumstances. If he were convicted of the charge, it would not be proper. In the Jackson case, which was reversed, the defense called a witness that was disgruntled with the state of Florida based on the charges that he received. And if you read the Jackson case, they called him, and we are allowed to cross-examine the defense witness that he had he got, quote, walloped with a 25-year sentence, and he thinks he was wrongly accused. Therefore, he has a bias against the state of Florida to come testify. The prosecutor in the Jackson case went further to say, and isn't it true that you were convicted of aggravated manslaughter? And then in closing, the court allowed that, and then in closing said he's a baby killer. And the court said, you can't do that. That has nothing to do with the bias You can't go into prior cases and collateral impeachment on a witness and opening up a pending case by doing this. So let's assume for a second that he'll say that. I mean, he probably will. He said it in depo. I don't know what he's going to say in trial. But even if he said in trial, I was offended and that's why I came forward, it doesn't give them the right to impeach him on the state of Florida's allegation. If they had some impeachment that he had, I don't even know his situation, he had said previously that he's not offended by people making fun of women, maybe that would be admissible. It's hard to come up with a scenario where it would be, but let's say they have a witness that says he hates women. Yeah, maybe they could call that person to impeach. They said he's insulted by women. But they can't use a charge from the state of Florida to impeach his statement. I don't see a way that comes in. Thank you. And certainly, I guess I would agree with the court to the extent that this is a situation that we can deal with in trial. I mean, I don't think we need I just wanted to put, when I knew that there was an issue out there that the parties couldn't resolve, I wanted to put it on the court's radar. But I don't see a scenario where it's admissible.
Give me a moment, okay? Did you all read Breedlove that was cited in the Bell case that went back?
I've read that case.
Did you, Mr. Hill? Breedlove, 580 Southern 2nd, 605.
I see it cited here on the second page. I
Yes.
don't know it off the top of my head. I can pull it up and read it briefly.
I think it's appropriate to stay within the bounds of what is before the court, which is, so as to the first, I think we're just restating what we all know, which is, yes, those are the permissible grounds that you would be able to explore on cross-examination. No one can foresee the future. So to that extent, I'm going to grant the state's motion in limine. If you believe that in some way he has opened the door to additional questions, I think Breedlove gives a little bit, not exactly on point, but Breedlove, at least the Florida Supreme Court, talks about the matters of pending, which we all have kind of dealt with all the time. You have a pending case, the nature of the charges, meaning what is of public record. I don't see any preclusion from you doing that. The allegations that he has, the time he's looking at, I think we're all in agreement. But before the defense goes into basically an equation, that is, I think he has to offer it. He has to offer it as a reason why, his compelling reason. And then, is it in the interest of justice for you to go further than what is normally allowed by law? I think that's a game time decision. And it's generally accepted that before there is an area that you believe a quote unquote door opening, then you seek guidance from the court before you do it, before you ask the question instead of blurting it out. Breedlove talks about not only pending cases, but also investigation cases. Breedlove also talks about how related maybe investigations are to what is currently being put before the court. And the court, in an analysis, talks about the interest of justice and fairness, and maybe those are considerations that I would take into account at or near the time. But I think we all know what the law is related to cross-examination. It is wide. It's not, there is some curtailing to it based on these issues that are discussed in there. And so what I'm going to grant the state's motion. Before you go outside of what is normally done, Mr. Hill, I'm going to ask that you seek guidance from the court that the door has been opened, and I'll give you the guidance from there. But let him do it. So we don't know what he's going to do, what he's going to say. The state doesn't know. Apparently, you don't know, and so but I'm going to grant it at this point because I believe that to be the current state of the law. And so the impeachment, you can't get to impeachment until, an impeachment can come on feigning lack of memory, but there is a showing that's required by the rules of evidence. But you can't impeach, I don't know, or I can't remember until you go through the steps to do it.
And I understand the court's ruling. With regards to the nature and the specific nature of the charges, I haven't seen where this has been specifically addressed, and I'll go back and read Breedlove, but with regards to the 3 charges Mr. Alexander has pending, the charges are stated in 2 different ways on the information. As the court knows, we have the just bulleted, attempted second-degree murder, possession of firearm by convicted felon, tampering with evidence. But then further down, when it actually explains those nature of the charges, I want to make sure I'm clear with the court's ruling.
I think that,
That's just what I want to make sure I'm clear
oh,
on.
sure. I think that you can go into, you're charged with attempted second-degree murder. And there's a firearms enhancement. All that is fair game. I don't think the state's objecting to that, are you?
I'm not. I think he wants to read the information that the alleged victim's name and then go further. I think what Mr. Hill is asking is to read the information, which I do have an objection to. I don't have an objection for him to say, I'm charged with the attempted second-degree murder and facing a 25-year minimum up to life imprisonment. and tampering with evidence. I think the case law is clear that that's admissible, but he's starting to talk about who the alleged victims are, and that's the facts of the case. For all I know, the witness could be saying, I've never met that woman a day in my life. I don't know why I'm charged with her. I don't know who she is. I didn't shoot any women.
And that may be his answer.
Well, but that's the
I don't know.
whole point is we're getting into a charged offense where he has a Fifth Amendment right, and, you know, it's not relevant to any material issue in the case. The material issue in this case is whether or not he's biased, and the charges and the amount, how much time he faced goes directly to that, and that's why it's admissible.
So in Bell, the two questions that were posed to the witness where it was found that the Fifth Amendment was, the court should have allowed the answer. It was, you've been charged by indictment of X crime. That has been, basically, the witness should have been permitted to answer that question. I can go, hold on.
Same thing.
You're not going to suggest it because he hasn't been charged.
No, you can talk about you've been arrested as well, and it's pending. I agree with that. You can't, yeah. You can't go. My objection would be you're charged with children. Yeah, yeah.
I can go back to Jackson, but maybe we're splitting hairs, but saying you plan on reading the information to him.
See, again, this kind of goes back to the court's first question. We're kind of going off what we anticipate his answers may be based upon his lack of memory throughout his deposition. There was some confusion for him as to what he was actually charged with. He would have to consult with his lawyer.
Really?
Yeah.
Well, I mean, I don't, right now, where I'm at is that ask the normal questions. We have to see, I guess, what he decides he's going to end up doing. If he says he doesn't remember what charges that he has, then, I mean, then they can go up with the information and put it in front of his face and say, you haven't seen anything like that, and they can start reading from it. They can do all kinds of things, and I think we're too far afield into hypothetical land. Right now, I'm going to grant the state's motion. We'll see what he's going to do, and it's going to be a game time decision about how far they can go or not. If he's going to be that, from what y'all are describing, if he's going to be that uncooperative, I think that they can go through the normal means to either refresh his memory, to ask him questions.
I don't, that's a different, if he says, I don't know what I'm charged with, that's a whole different
Right.
ballgame.
I mean, I don't know. So, and y'all don't, it doesn't seem like y'all know, so.
He says he doesn't know. I've never said I don't know what the defense of the witness is.
Okay, well,
I don't know what any witness is ever going to testify to.
right.
Until
Well,
they get on the
I'm
witness
just saying, I think that we're getting too far, like, could that happen? Yes, I think so. But right now, I'm within the, ask him the normal questions.
I understand, Judge.
Okay.
They filed their motion, so we had to.
All right, no, I get it. So at this point in time, is granted without prejudice to re-raise. Okay,
Thank you, Your Honor.
thank you. Is there anything else for today?
No, Your Honor. We can. Your Honor, the defense filed a judicial notice request of Your Honor.
And I saw there was an objection.
We objected to it, so.
It was about the firearm, right?
We simply want the court to take judicial notice of the fact that the FBI used that firearm from whatever it is, 1986 to like 1996. For the purposes of today, it doesn't matter. Ironically, the state doesn't disagree that that is a fact. They don't disagree that the FBI used that firearm and then discontinued it. What Mr. Mizrahi, as I anticipate, although today he keeps telling me I'm wrong, as to my anticipations, is they want more information. They want the jury to know that it wasn't the greatest firearm. It didn't work good. It had high recoil, whatever the case may be. And as Mr. Mizrahi said to me, facts that come in as judicial notice have to be facts that there's no disagreement upon. And ironically, the example that he gave me was it's 72 degrees outside. That would be something the court could take judicial notice of. But neither party disagree in this case that it's 72 degrees outside. What Mr. Mizrahi tells me is, yeah, but I want to know more. Well, maybe it's 72 degrees outside because of global warming. That there would not be an agreement on. Maybe it's 72 degrees outside because there was an extreme heat wave in Alaska. That would not be. But the very idea that it's 72 degrees outside, stop. The state does not disagree. And what it says is facts that are not subject to dispute because they are capable of accurate and ready determination by resort to sources whose accuracy cannot be questioned. I provided them with a letter from the director of the FBI when they started using the firearm, and I provided them with evidence that the firearm stopped being used. And they don't disagree with my sources. They have told me they don't disagree that they're experts and the people they've consulted with and the gun enthusiasts in their office all know that this is a fact. They just don't like that that fact alone is coming in. They can call anybody they want to put in whatever information they want about the 10 millimeter. I just don't want to be in a position to have to pay somebody, although I've already listed somebody from the FBI who I will call on Zoom to put that fact in if I have to, when there's no dispute as to that fact. I'm not preventing the state from putting in other facts if they so choose. If they're going to call someone from the FDLE who's a firearms expert, and they're going to say, what was the problem with the 10 millimeter? It had high recoil, it had high velocity. That's it, fine. Maybe if they know something about the 10 millimeter, I'll get a bunch of testimony out that it's not all that rare of a firearm. Millions of them are made, and every manufacturer has made that firearm. I'll take advantage. But it is not subject to dispute that it was the issued standard firearm of the FBI from 1989 to 1997.
Okay, thank you.
And our objection is multiple faceted. I think the notice was asking that it was a 10 millimeter. The 10 millimeter, in regard to this case, our firearms expert would testify that it was a Glock 10 millimeter. The FBI firearm was a Smith & Wesson 10 millimeter. These are the kind of nuances. What the defense is asking you to take judicial notice of is essentially DNA is unique between everyone except identical twins. These are not facts that typically are judicially noticed. While I agree that the FBI may have had, and they in all likely did, issue a 10 millimeter firearm during the specific years in question, that is not a statute or a regarded temperature at a particular time. And so we don't think this is appropriate for judicial notice, and would ask the court to deny it. And certainly the defense has already listed somebody that can certainly cross-examine any of our witnesses that have the information about what the FBI may have had. I don't see this as an issue that needs to be judicially noticed. It won't take any more time from the jury. It's not a complicated issue. You know, judicial notice is usually about, these are the laws of Kentucky. You know, this is the registry of something. You know, the person was on probation, whatever the case may be. So I don't think this is appropriate for judicial notice. We have objected to it and thinks that kind of evidence that needs to be presented is evidence that should be subject to cross-examination.
Okay, Mr. Dreiss, I'll give you last word.
I don't have anything further.
Okay. All right, I'll issue an order on it. All right, thank you. Court's adjourned.
Our next court day is Tuesday?